Hi comrades, yours Kayveeyes. Comrade Janardhan Mazumdar, our Deputy General Secretary of the All India Postal Employees Union Group C, asked me to post a video on the time limits prescribed for the disciplinary proceedings. Based on his request, I am just capitalizing the time limits for the process of the disciplinary proceedings in this episode. Number 1. After the issue of the charge sheet, the time limit for submission of defense has to be given 15 days. If the charged officials want 15 more days time, that can also be considered. But the overall limit for filing the reply, that should be made within 45 days. This is as per sub-rule 4 of Rule 14 of CCS Rules 1965. Number 2. The time limit for producing the requisite documents claimed by the charged officer or issue of non-availability certificate, that should be made within 1 month from the receipt of such requisition. Some documents may be required, it may be supplied or it may not be supplied. But the process has to be completed within 1 month, that is as per sub-rule 13 in Rule 14. The time period for the presenting officer to produce the evidence by which he proposes to prove the articles of charges, if the government servant fails to appear within the specified times or refuse or omits to plead, is 30 days. Suppose he is not either refusing or not attending the inquiry, he has to produce, the presenting officer has to produce the evidences within 30 days, and that should be completed within 30 days. That is sub-rule 11 of Rule 14 of CCS Rules 1965. The time limit for inspecting the documents produced by the presenting officers for the purpose of preparing the defense is within 5 days of the order passed by the Enquiry authority. This can further be extended for another 5 days. Totally 10 days only permissible. This is as per Rule 11(1) of the Rule 14 of CCS Rules. The notice period for production of any documents which are in possession of a government but not mentioned in the list of documents with the charge sheet, but a request in this regard is made by the charged officer, the enquiring officer may allow 10 days for the purpose, which can further be extended for 10 days. This is as per Rule 11(3) of Rule 14. The time limit provided for the adjournment before the close of the case for presenting officer to produce evidences not included in the list given to the charged officer or enquiring authority himself, call for the new evidence or recall and re-examine any witness. Such adjournment is done 3 clear days excluding the date of adjournment and the date to which the inquiry is adjourned. That means 5 days total from the date to end, 5 days. Production of any new witnesses or recalling of witnesses, the period has been prescribed of the 3 days excluding the 2 days. This is as per sub-rule 15 of Rule 14. The time limit for completing the inquiry and submit the report by the inquiry authority in terms of notification dated 2/6/2017, the inquiry authority should conclude the inquiry and submit his report within 6 months from the date of receipt of his order of the appointment. When an inquiry officer is appointed, he should complete the process, he should expedite the inquiry, and he should complete the inquiry within 6 months. Actually, he should submit the report within 6 months. An additional time not exceeding 6 months for completing the inquiry can be allowed at a time on the basis of sufficient and good reasons to be recorded in writing by the disciplinary authority. Generally, it should be completed within 6 months. If there is sufficient reason due to the protraction of the inquiry on one pretext or the other, or due to various reasons, the disciplinary authority can further grant, and anyhow that should be completed within 12 months from the date of appointment of the inquiry officer. This is under sub-rule 24 in rule 14 of the CCS rules. The time limit for furnishing written representation by the charged officer on the advice of the UPC is 15 days from the date of receipt of the copy of advice by UPC by the charged officer. This is as per Rule 3B of the Rule 15. In respect of the time limits for sending proposal to CVC for first stage of advice, when the proposal for first stage is referred to CVC, when there is any vigilance angle, very financial embezzlement, or any complaint about the vigilance factor, that should be referred to the CVC for the first stage of advice within 1 month of the receipt of the investigation report. If the vigilance angle is not involved, the case should be put up to the disciplinary authority for taking a decision to initiate disciplinary action under the CCS rules within 1 month from the date of the receipt of the investigation report. Nowadays, even for issuing the charge sheet, they are protracting years to year. But as per the rule, when the investigation report has come, the disciplinary authority has to decide whether it can be proceeded or not within 30 days. That is, within a month he should decide. This is as per DOPT orders dated 29/11/2012 order. The time limit to put up the case to disciplinary authority after the receipt of the first stage advice of CVC for taking a decision to initiate disciplinary proceedings is within 1 month of the receipt of first stage of advice of CVC. This is also as per 29/11/2012 order. The time limit to issue a charge sheet to the charged officer once a decision is taken by the disciplinary authority to initiate the disciplinary proceedings, the charge sheet should be issued within a week from the date of receipt of the decision of the disciplinary authority. You can take a decision within 1 month, but charge sheet should be issued within a week from the date of decision of the disciplinary authority. This is also as per 29/11/2012 order. The time limit for seeking representation of charged officer on inquiry report and disagreement of disciplinary authority, if any on it, the charged officer may be allowed 15 days to submit, if he so desires, his written representation or submission to the disciplinary authority. This is as per order dated 29/6/1989 of DOPT. And in short, in nutshell, the DOPT has categorically stated via its OM dated 14/10/2013 that the time limit for concluding major penalty proceeding should be completed within 18 months from the date of issue of the charge sheet to the charged officer. Anyhow, any disciplinary case under the Rule 14, that should be completed within 18 months. If it is not completed within 18 months and it is being protracted, what is the remedy with us? We can represent to the next authority that the case is unnecessarily being prolonged, and also resultantly you are not getting your other benefits and etc., and also you are having various mental torture, mental agony, everything you can mention, and you can represent to the next authority, and you can seek expedite disposal of the inquiry as per the rule, and we explain in the pre-paras. With this, I am concluding this episode. I hope this will be more useful to all of you. Thanking you, comrades. Yours, Kayveeyes.